All right, so my apologies, y'all. I think this is the first virtual oral argument I've ever participated in, so I'm a bit stubborn. The audio seems off to me. We're going to do our best. I want y'all to know that we have reviewed the briefs. And we're here for Mr. Boatwright first. When you're ready.
Thank you, Madam Chief Justice, and may it please the court. Mr. Fu signed a contract with an arbitration clause that applies to any and all disputes. He also initialed a Texas-specific arbitration clause acknowledging that he was foregoing litigation, but he ignored his promise to arbitrate and filed a lawsuit instead. Now he says he's been prejudiced by the consequences of his decision to breach his contract. He complains about paying his lawyer for discovery that he requested, and he says the litigation has dragged on even though he waited a year to take basic steps like notice depositions in his own lawsuit. The bottom line is that Mr. Fu broke his promises and is complaining about the money and time that his broken promises have cost him. This court should make Mr. Fu keep his obligations. It should hold him to his claims that they must be arbitrated. It should make sure that he arbitrates the claims that he agreed to arbitrate, just like he'd originally promised to do in his written, signed, initialed, and detailed arbitration agreement. Now, I'll briefly explain why Mr. Fu is required to obey the arbitration clauses he agreed to obey. Then I'll address each of his arguments one by one. Mr. Fu must comply with the arbitration agreement that he expressly agreed to follow. He signed a contract containing a series of addendums that were expressly incorporated into his contract with Complete Solar. One addendum included an arbitration clause that required arbitration of all disputes. Mr. Fu initialed that arbitration clause. The addendum also provided that by initialing the arbitration clause, Mr. Fu was giving up any rights he might possess to have the dispute litigated in a court or jury trial and appeal. And it also notified them that if he...
Ask you why you waited to assert the arbitration clause. I mean, I understand that that's your position, that he signed it, it's clear. But you waited to assert your motion to compel arbitration. I mean, if it's that clear, why wasn't it brought up with your answer or raised earlier?
Your Honor, I'm not sure why the trial counsel made that decision. I know that we responded to some discovery requests, but we also communicated with Mr. Fu's counsel about pursuing mediation and arbitration. And as soon as Mr. Fu took an affirmative step in court and noticed depositions, we immediately moved to quash the depositions. And then just a couple of weeks later, we moved to compel arbitration. And I want to acknowledge that taking a year could be a factor that a court would consider in a case like this. Your question is absolutely well taken. Under Perry Holmes, though, the court should look at a totality of factors and weigh the fact that Complete Solar took a consistent position in this proceeding and never took an affirmative step in litigation, never noticed or took any of its own depositions, never moved to compel discovery and so forth, the kinds of factors that were important and in fact dispositive in Perry Holmes. And the Texas Supreme Court has been clear about how important or not important delay in requesting arbitration can be. For example, the Texas Supreme Court held in the Prudential Securities versus Marshall case, that's 909 Southwest 2nd in 2008, that a party does not waive a right to arbitration merely by delay. The court also held in the Richmont Holdings versus Superior Recharge case, 455 Southwest 3rd 573 in 2014, that a delay of 19 months did not constitute a waiver. That is because under Texas Supreme Court precedent, delay alone is not the test. Intentional conduct inconsistent with claiming a known right to arbitrate is, according to the Texas Supreme Court in the Sun Exploration versus Benton case in 1987. That's 728 Southwest 2nd, 35 at page 37. So the case law is clear that moving to compel arbitration in 12 months does not waive arbitration, so long as the movement follows a consistent position on arbitration and litigation. And when a party, like each appellant in this case, acts consistently and takes steps only to resist litigation and arbitration, it does not waive arbitration.
Mr. Boatwright,
Yes, ma'am.
can I ask you to help us out here with the trial court obviously ruled against compelled arbitration. How do you see the standard of review applying in regards to that decision?
I believe it's de novo. It's a pure question of law here. There are no questions of fact. It's a contract interpretation matter. Does the contract mean what it says?
Well, what happens, I guess more specifically, that should have been clear, I apologize, with your discussion of the Perry home factors and whether or not there's been invocation of the courts to such a degree that it results in a waiver. Does that in any way impact the standard of review? Or do we still have the full de novo opportunity to look at the factors?
I think that a de novo review would include a consideration of the Perry Homes factors as a decision as a matter of law, that the court would determine whether there's waiver based on its evaluation of whether the Perry Homes factors are present, whether a consideration of the totality of factors, weighing the 12 months that elapsed until we requested litigation against Mr. Fu's decision to violate his arbitration agreement and to wait a year to notice depositions in his case. And above all, as I said before, under Texas Supreme Court authority, whether we have taken a consistent position on arbitration and litigation, and we have. Unlike the unsuccessful movement for compelling arbitration.
How is it consistent to answer discovery and also not file a motion to compel arbitration?
So under the case,
the conduct we can look at, the conduct of Complete Solar, I suppose, is being served with a lawsuit, accepting it, filing an answer, eventually responding to the written discovery, and not filing a motion to compel arbitration, which would, your argument is saying that it was very plainly and clearly written in the contract. Therefore, why you're not giving us anything in the record about the delay? What compelled the delay?
So there is nothing in the record that would explain the 12 months. I would only say, Your Honor, that under Perry Homes and lots of other Texas Supreme Court precedents, including the ones that I've cited to the court today, that delay is not the key factor here. It's a factor, and the court should consider it when it considers the totality of the factors. But delay alone under Texas Supreme Court precedents is not the key factor. Instead, it's consistent position, a consistent course of conduct, whether we have taken affirmative steps in litigation. Like, for example, the unsuccessful movement in Perry Homes noticed and took 10 depositions. The movement filed 5 motions to compel discovery. The movement, above all, initially resisted arbitration and filed a 79-page objection to it. That's just categorically different from our conduct here. And as soon as we were faced with notices of depositions, we immediately moved to quash those depots, and soon thereafter, just a couple of weeks later, we moved to compel arbitration. I think that's consistent litigation conduct under Perry Holmes and the other cases I've cited. You should absolutely consider the 12-month time period. But again, the Texas Supreme Court has held that a 19-month time period does not waive arbitration. So we're well within that. And
Mr. Bowman,
yes, Your Honor.
if I understood you correctly, you stated that Complete Solar and Mr. Fu discussed mediation and arbitration during the course of the litigation. Is that correct?
Yes, Your Honor.
And aside from the November letters acknowledging that mediation did take place and Mr. Fu confirming that, what other evidence is in the record before us speaking to those discussions during the litigation process?
In our briefing, we cited to an email exchange, which I can find for you and pinpoint, in which the parties discussed mediation and arbitration.
Was there anything besides that email string?
Not that I'm aware of. I'd be happy to submit a supplemental brief or letter if that would be helpful to you. But as I understand it, the parties did exchange emails acknowledging the mediation and arbitration provisions of the contract that they signed, and then mediation absolutely did take place, and the parties mediated before the trial court signed the order that's appealed, and we informed the trial court that we had mediated the case before the trial court signed the appealed order.
Thank you. And my other question is, you refer to a 12-month time period, presumably being from the time that the lawsuit was filed until the time that we're dealing with now. Why would we count the time of filing versus the time that you answer?
I don't know. So in the case law that's reviewed cases regarding where questions of waiver of arbitration have been raised, the court seems to count the time from the time of the lapse of months from the time period of filing. But I'm not aware of any case law that says that this particular event or that particular event is when you start the clock. I think the court is free to say that the relevant event is when the plaintiff filed the amended petition, which is the live pleading and the one that governs this case. I think the court is also free to count any reasonable event. I'm not sure of any binding legal guidance that would say that this event or that event controls here. Instead, what I'm saying is, even if you count from the very beginning, even if one were to come up with a period that is as long as it can possibly be, we are still at 12 months. That's the longest possible period. We are still at 12 months, well within the time period that the Texas Supreme Court has previously held is not a waivable delay. It's not a delay that constitutes waiver.
Okay, so you're not necessarily advocating for the time that you're served or your client is served. You're not advocating for the time that your client actually appears in the lawsuit or acknowledges its appearance. You're saying that even if we take the longest possible time, you still prevail.
I'm saying even if there are, your question is extremely well taken, as it should be, Your Honor. Counting the time period from when we learn about the lawsuit would obviously be a very equitable and reasonable time period as well. And other events, for example, the filing of the amended petition would also be a time to start. My argument is that even if one were to take the most ungenerous period of time possible for my clients, we still come in well within the Texas Supreme Court's allowable time for filing a motion to compel arbitration. Thank you.
Thank you.
All right. If there are no other questions on that matter, I'll move along. Besides Perry Holmes, none of Mr. Fu's other arguments for waiver have any merit either. Uh, he claims that arbitration is improper because mediation is a condition precedent, but mediation has occurred, and it occurred before the trial court signed the order that we are appealing. Mr. Fu also suggests that his fraud claim cannot be arbitrated, but that is incorrect. A claim is subject to an arbitration agreement if the claim is enmeshed with the contract, meaning that it could not stand alone without the contract.
Mr. Boatwright,
Yes, Your Honor.
excuse me, but is that our determination to make if what you're arguing is true that this case should go to arbitration? Isn't that for the arbitrator to decide and not us as the court?
It absolutely is, and that was our argument in the brief, that this is a question for the arbitrators. But even if it weren't, even if the court wanted to explore the law on this, I think that the law would totally support the proposition that his fraud claim has to be arbitrated.
And you think that
yes.
you would be within our jurisdiction and discretion to explore that question?
I think the court is free to discuss whatever it wants in an opinion. I think judicial opinions frequently say this is we're not reaching this question. We're not deciding this case on such and such grounds. But if we were, here's what we would say. The court is free to, I think, opine on whatever it wants. I do think that the question of whether his fraud claim should be arbitrated is a question for the arbitrators, no question about it. But even if it were a question for this court, I think that the fraud claim should be arbitrated because it's enmeshed with the contract. Mr. Fu expressly pleads that his breach of contract claim is based on the facts that he pleaded in his other causes of action, including his common law fraud claim. I see that I have 3 minutes. I'll move on to my final arguments unless the court has any more questions about fraud. Mr. Fu claims that the court has no jurisdiction. I think that's incorrect. The trial court first signed the order denying our motion to compel arbitration on November 20th. And we filed our notice of interlocutory appeal on December 8th, which is well within the 20-day period for filing the notice. Under Rule 26.1, our appellate deadline ran from the date the appealable order is signed, and so this court does have jurisdiction. Finally, I think it's important to note that Mr. Fu's brief rarely cites the record or makes an attempt to explain what he means. I'll give you one example, but there are many others. In his discussion of dividend, Mr. Fu does not try to show what dividend has to do with this appeal or how dividend affects Mr. Fu's contractual obligation to arbitrate his claim. And the only record citation in the discussion of dividend is to trial court briefing, not evidence. Mr. Fu is required by Rule of Appellate Procedure 38.1 to provide a clear and concise argument for each contention made with appropriate citations to authorities and to the record. And both the Austin court and this court have recently held that failure to follow that requirement can waive appellate arguments. All of Mr. Fu's contentions that failed to provide a clear and concise argument with appropriate citations to the record and authority are waived. But I think you'll notice in our briefing, even where we specifically pointed out the arguments that are waived, we still tried to provide the court with a full legal analysis to guide the court's resolution of the matter should it decide that the points are not waived. The court should reverse the trial court and hold that Mr. Fu must arbitrate all of his claims, just like he expressly agreed to do in his signed and initialed arbitration agreement. He does not argue that the agreement wasn't complete. He doesn't argue that there is no arbitration agreement. Instead, he makes waiver arguments that are wrong under Perry Holmes. He makes a condition precedent argument that is moot by our decision to mediate the case already. His arguments have no merit. We ask the court to reverse the trial court.
Mr. Boatwright, in the defendant's motion for reconsideration of the motion to compel arbitration, that appears to be as requesting arbitration between only Complete Solar and Mr. Fu. Is that correct? Or were the corporate individuals left out inadvertently? Was that on purpose? Is that who are we dealing with right now on this appeal?
Your Honor, I think the only party that can be compelled to arbitration is Fu here in this matter. I think other parties are welcome to arbitrate. I thought our arguments previously about compelling dividend were solid, but we're requesting that the court compel only Mr. Fu to arbitration and not the corporate officers.
And so where does that leave the corporate officers if the motion was originally, or let me ask you, was the motion originally by the three, Corporate Solar and its corporate officers?
The original motion to compel arbitration, if I remember correctly, was to compel Mr. Fu and Dividend to arbitrate. In the motion to reconsider, we did not ask the court to compel Dividend to arbitration, only Fu. And the only party that we are currently trying to compel to arbitration again is Fu, and that is the only party that is, as I understand it, resisted arbitration under the motion to reconsider.
So it is your position that whatever Fu's claims are, they all go to arbitration based on your motion to compel?
Yes, Your Honor, that's correct. And I want to point out, just for the sake of clarity, I'm not intending to waive any argument that we ever made with respect to Dividend or any other party. I'm just informing the court that our current that the appealable order denied the motion for reconsideration, and that motion for reconsideration sought to compel only Mr. Fu to arbitration.
Right, and I understand that the appeal was by Complete Solar as well as the two corporate individuals.
Yes, Your Honor.
Thank you.
All right, Mr. McMillan? When you're ready.
Thank you, Your Honors. May it please the court, this case is about fundamentally what is a substantial invocation of judicial process.
You may need to speak up a little bit. We're having a hard time.
Can you hear me? Can you hear me good?
We can hear you, you're just a little soft, so if you can just raise your voice a little.
No worries. So this case is fundamentally about what is a substantial invocation of judicial process, what would be a perverse incentive scheme for an arbitration clause, what is a contract modification, what would be a consent to this forum as opposed to arbitration, and what constitutes waiver and estoppel. So I kind of want to telegraph my arguments, and then we'll kind of go into them, each of them in turn. So to start with, our main argument is under Perry Holmes and the Morgan versus Sundance case. This is fundamentally about what is substantial invocation, and is prejudice necessary or not. So that's our main argument. Then, I want to take some time also to go through our 4 alternative arguments, and these include the argument on condition precedent. These include the argument about waiver, about dividends, consent, and what we could call the fraudulent inducement argument. And then finally, I'd like to conclude with addressing some of Mr. Boatwright's points. So again, to go into our primary argument with the Perry Holmes case and the Morgan v. Sundance case, arguably Perry Holmes is the binding precedent in this case. It's Texas Supreme Court 2008, and it sets up a 2-pronged standard for when an arbitration clause is waived. And the first prong is substantial invocation of the judicial process. And Perry Holmes lays out a variety of factors to consider when deciding whether the judicial process has been invoked. It's interesting to note, obviously, Mr. Boatwright points to the extreme facts of Perry Holmes, but if you'll notice in his reply brief, there's very little of citation to the actual factors because the law and the standard that the court lays out is very favorable to us in this case. So just to kind of go, in our brief, pages 16 and 17, factors are, how long the movement delayed. The court focused a lot on that in Mr. Boatwright's argument. but also is another factor is whether the movement knew about the arbitration clause all along. Here, this is a Complete Solar standard contract. How much pretrial activity related to the merits? In this case, there was discovery that related to the merits. The time and expense incurred in litigation. Here, there was evidence in the record and before the trial court that Mr. Fu incurred great expense. And then also, we do agree with Mr. Boatwright on the acting inconsistent with the position that is the standard, and we would say that there has been an inconsistent action. So the most important, the Perry Holmes case says any factor is enough, but what I would point to is the single sort of deciding factor, the deciding move that Complete Solar made that waives their right was responding to the discovery. And the reason that is because, thinking about this and looking at the standard is substantial invocation. So, two words, invocation, substantial. So to invoke is to invoke the court's authority, and substantial means it has to be something more than trivial, but, from the Latin, substance is some sort of essence. It has some sort of substance or thing, and any substance is enough. So I would say that a general denial, even guilty people can make a general denial. That would be maybe something trivial, maybe even initial disclosures as well, although that's not before this court. But when we're responding to discovery, we put in work to, prove our case. We've sent forward the discovery, and the Texas Rules of Civil Procedure mandate good faith. You're anticipated to respond with good faith and engage in the judicial process. We're not supposed to be making bad faith objections or not responding to the discovery and making the court get involved. And so when Complete Solar has 30 days, they have their counsel look over it, and instead of objecting because there's an arbitration clause and filing a motion to arbitrate, they respond with not all the documents. They don't give us the correct RFAs. They're giving us incorrect answers on RFAs. They're not giving us any interrogatories. And as the plaintiff, we have to move forward to prove our case. And so they're essentially making us do work as the plaintiff. And I argue that at that exact moment, they have substantially invoked the judicial process. That's the one factor. And that's the inconsistent action that Complete Solar did to invoke the judicial process.
Would you agree that cases looking at this issue, that would be on one end of the spectrum where you have responding to discovery, where you have other cases where it is the 10 depositions, it's motions to compel there's a whole range of that. Would you agree that this is on the lower end in terms of, but you're saying it's substantial? When we look at these cases where you have a motions to compel arbitration, and not frequently is it just discovery where you find waiver. Wouldn't you agree the cases are looking at where there are hearings before the court, more pre-trial matters being before the court, and this is between the parties. And really the plaintiff brings a lawsuit. You're the one that has to do all that stuff anyways, whether there's arbitration or not. So suggesting that a defendant waives arbitration because they respond or answer a lawsuit, it seems to me maybe not on the substantial end. I know you're arguing the opposite, but I'm just saying, if you look at the cases,
Sure.
there is a range, and this may be on a lower range.
Sure. Well, there's always got to be a range. Whatever the standard is, there's got to be an extreme violation of the standard, and you just meet the violation of the standard, right? Whatever the standard is, that has to be necessarily the case. But what I would argue is that the key thing here is that the delay is strategic, right? And so it's if you know that you have an arbitration clause and you're strategically doing it. In the Perry Holmes case, these are litigants, at least, not, compared to my client, those litigants have much more money. There's much more lawyers, right? It's not just Garrett. It's not just Mr. Fu. The Perry Holmes, and I would argue the Texas Supreme Court set up the standard for an extreme case. As you all know, we have discretionary review in the Texas Supreme Court, and they're setting up a standard for we'll call it the rest of the people, right? And, I would argue that, we meet the factors. There has to be sort of a minimum, and there's evidence in the record and that the trial court considered that has, we were prejudiced. And kind of going back to, again, the Perry Holmes versus Morgan versus Sundance, this is also kind of another wrinkle as in terms of which case is binding and which standard applies. So the Morgan versus Sundance case, U.S. Supreme Court case, essentially overrules a bunch of circuit court cases on the Federal Arbitration Clause, Federal Arbitration Act, and essentially says we consider this like a normal contract, right? There's no sort of statute that says, hey, we have a generic policy to just favor arbitration clauses over other contract clauses. It's about the contract clause itself. And
Mr.
so,
McMillan,
go ahead.
I understood that Mr. Fu initialed as to the TAA as well as the FAA. Does that not matter in terms of your argument about applying Morgan?
I don't think so. Mostly because the TAA and FAA are, according to my understanding, relatively similar, and I think the same standards would apply. That's at least my understanding. So, but kind of going back to the contract modification, I think here, and this relates again to the substantial invocation. The reasoning behind substantial invocation is essentially because you're consenting to the forum. So I argue that again, when Complete Solar responds to the discovery, it's almost like a contract modification or a consent to the forum.
Mr. McMillan, excuse me. I understand semantically, I may agree with you in terms of what substantial invocation means. But as an intermediate court, we're bound by the precedent of the higher courts. And I'm not sure how that reconciles with substantial invocation of the judicial process as defined by the factors in Perry Holmes. And so if I understand you correctly, you're arguing that by virtue of answering discovery at all and by objecting and creating more work for the plaintiff, because then you have to fight to get what you're asking for or fight to get the answers that you think you should get, that's substantial invocation. But as I understand it, as an intermediate court, what we're looking at is Complete Solar producing probably minimal discovery, and that discovery being documents that Mr. Fu probably already had to at least to some extent or to a large extent, and those documents being documents that are relevant to the arbitration process. So so I just want to I just want you to appreciate that, we have to look at the law from those standards as opposed to just a dictionary definition, which we may very well personally agree with you about semantics, but this is not that. This is those factors. And certainly if you look at our precedent under Rivas v. Molina, we have acknowledged that perhaps, whereas something may seem minimal in terms of discovery, it could be everything for a case if the case is small. But here, the difference is trial wasn't set. It's less than a year between the time that Complete Solar knew about the lawsuit to the time that this moved on. I'm having a hard time reconciling your approach with what I think our approach has to be.
Sure. So let me kind of provide some context for why I think Morgan versus Sundance or Perry Holmes even matters. So the only reason I think they even matter at all, one, we're raising it because who knows how high, this goes on appeal. But also, I think that the court can consider it in its argument. But really the only difference is, does prejudice matter? Because the Morgan versus Sundance arguably eliminates the prejudice requirement in Perry Holmes, but Perry Holmes has the two factors: substantial invocation, prejudice, and Morgan v. Sundance has substantial invocation, period. And so in both cases, you need substantial invocation. And in both cases, we argue we have substantial invocation. The question is prejudice needed or not? And I think prejudice has been shown here. And so that's really only if Morgan v. Sundance doesn't apply, then that just means we have to have an additional showing of prejudice. And we have our We have in the record, and the trial court considered the evidence of prejudice, the additional delay by Complete Solar. We were promised, just to kind of give some background on this case, we contracted for solar panels in late 2022 in the fall, and they promised that they were going to have them done by December 2022. And in December 2022, they came to us and said, not going to happen. We messed up. We're not able to do it. Here, please sign this additional contract modification, which we argue is fraudulent inducement and invalidates everything. That's one of our minor points. And we sign it, and they said they were going to have it to us in early January, and they didn't have it to us in early January. And not only did they not have it then, they failed 7 additional times. Then they stopped trying after a year. Then we finally had to sue them. Then they were going to give us, some sort of settlement. Never happened. Never were able to pay for mediation. And then after a year of litigation, when we moved forward, then they moved to arbitrate months after they responded to discovery. So that's all the prejudice. And every single month, we are paying their loan. We're paying the electricity that they promised that they were going to eliminate. And we're paying the attorney's fees. Mr. Fu's paying me, the attack dog, to go after this, firm that's able to hire and fire lawyers, almost like we're going through Iranian leaders, right? So that is the prejudice that my client's experiencing, and the trial court considered all of that evidence. So I'd like to then also,
Can I ask one more question? I'm sorry, Mr. McMillan, I apologize for interrupting. I just have one other question. Can you explain to us, so if I understand you correctly, you're counting as prejudice the payments that Mr. Fu had to make during the pendency of this litigation. But my understanding is Mr. Fu filed the litigation. Did he try to mediate or arbitrate? And if so, was the issue cost that he was made to pay for it, or was there an issue there? I'm just trying to understand why he filed the lawsuit.
Sure.
Without.
Yeah. So yes, that goes into one of our minor arguments. We'll call it our first minor argument, or alternative theory, that that we shouldn't be compelled to arbitrate. So that is that there was a condition precedent to mediation. So if you look at the contractual language, which is again the whole reason why there's supposedly an arbitration clause, is because it was in contract. And we agree, we signed the contract, and it said mediation is a condition precedent. And so our position is that we were always able to go to mediation. We were always open to it. But Complete Solar, after all this fraud, making us trying to put on the turn on the panel 7 times and then giving up, they wanted us to pay for mediation, and they weren't really going to make any effort in having that happen. And so we sued them, right? Because that's our right, and they're making DTPA violations. Now, let's say that was completely incorrect, right? Let's say we should have just gone to mediation. We needed to pay for it. Everyone agrees that if we had some sort of agreement, let's say we had a contractual modification, right? That says, hey, Complete Solar, Andy Fu, we know we hate each other. We know we don't like each other. But let's just agree. Let's just modify the contract one more time. We're going to litigate in court, right? Everybody would agree that that would be okay to do. And we argue that that is exactly what happened. So regardless of what the mediation is condition precedent said, we sued them, and by responding and then again substantially invoking the judicial process, which is the standard, when they respond to that discovery, they have consented and essentially modified the contract. They've consented to the forum. And again, your Honor brings up the Perry-Holmes factors. And so let me just kind of map on the substantial invocation and kind of my contract language to the Perry-Holmes factors. So going through the kind of the 5 that I've written down, we have whether the movement knew, okay? This is their standard contract, Complete Solar knew. And that's how they consented, and consented to modify essentially, hey, we're all good with suing, right? That's essentially what they did. And that's a Perry-Holmes factor. How much of the pretrial related to the merits? We sent discovery, they answered it. We think it wasn't in good faith, but even if it was, even if they sent us all, 2,000 pages of discovery and it was all good faith and they complied with, their obligations and rules under the civil procedure, then that matches merits pretrial discovery. And therefore, they're substantially invoking the judicial process because they're saying, we agree, Mr. Fu, we will, even though we disagree and you should lose your case, we're okay to litigate it in court. Time and expense in the record. Again, we've put on record, evidence of our attorney's fees, the electricity, the loan, those three factors, or those three expenses are incurring us prejudice every single month that Complete Solar strategically delays in moving to compel arbitration. And again, they're doing it by cycling through, I think they went through three firms, and probably I believe multiple CEOs as well. That's a Perry Holmes factor. Perry Holmes says few or even a single factor, right? So, and again, Mr. Boatwright, we focused on the year and kind of the time, and Mr. Boatwright is correct that that's not, 12 months isn't necessarily, we've had cases where there was 19 months, right? Or we've had kind of different kind of amounts. But I would argue that the single factor is that under Perry Holmes can invoke the judicial process is the responding to the discovery. And after 30 days, you had a lawyer, you reviewed it in good faith, in compliance with the Texas Rules of Civil Procedure, and you said, here's our stuff, you can review it, and you can start to move forward with your case. And then months later, that wasn't the case. And Morgan v. Sundance, just to bring it back, because Morgan v. Sundance focuses on the substantial invocation, which again is the first prong of Perry Holmes. Morgan v. Sundance says that the focus is on the movement's conduct. So Complete Solar's conduct, and Mr. Boatwright seemed to agree with that standard. The focus is on, is Complete Solar's position inconsistent? And his position seems to be that because they haven't filed some sort of motion with the court, or they haven't sent their own offensive discovery, therefore their position is consistent. But I argue, and I think the sort of real world law truth is that it is inconsistent, because they're not just going on offense when they file a motion or send us discovery. When we send them discovery and they respond, we have to look at that. We have to use it to move our case forward. We have to decide whether we want to compel, send deficiency letters, all of that in a sort of real world position. I tell my clients, every time I'm working on your case, I'm hurting you, right? Because I'm charging you money. I don't work for free. And so I'm hurting my client when I'm working on their case. And that then, and if the opposing side is sort of giving me work to do and I'm hurting my client, that is kind of the reasoning behind the substantial invocation.
Mr.
So-
McMillan, there's a couple of things with what you just said. One is the idea that any litigation, even if it's litigation brought by the plaintiff, starts the clock on prejudice, because every second you're spending is against your client. Well, then we just do away with litigation, right? That's like saying I filed a lawsuit and right away plaintiff is being prejudiced. I mean, that seems a bit of a stretch, but you're also asking us to announce a new standard that that if you don't take the position of a special appearance, for example, you waived your arbitration right. Because if I understand your position, you're saying the only consistent position would be to have filed a motion to compel arbitration as its first responsive pleading, gotten a hearing, and have that said. If that's true, then why do we have Perry Holmes and Morgan?
So, Your Honor, I appreciate the question, but I do disagree. I disagree for two reasons. The first is, yes, while it might be true, sure, obviously, anybody spending on a lawyer, I would call that prejudice. But prejudice isn't the only factor. It's substantial invocation plus prejudice, and sort of the incredible amount of time or effort in between their invocation and the arbitration. That's the prejudice. And then the second reason is, there's no special appearance needed, because again, the standard is substantial invocation, not a trivial, not sort of the answer isn't substantial. That would probably be trivial, right? It's when you're doing the substance of the lawsuit, which is what the discovery process is, and that is when it is triggered. So you wouldn't have to do a special appearance, But if you are, if you're responding and participating in discovery after you've looked over everything and you decide not to move to arbitrate, then you have knowingly consented to the forum and waived your right. And feel free to interrupt me. I do want to go through kind of my remaining arguments just in case there's any interest in those. One of our minor arguments, and these are kind of all in the alternative, is that there's been waiver of the deadline or missing of the deadline. There was 2 hearings. In both hearings, the judge, pretty clearly in his notes said motion to compel arbitration denied. And here, 4 months later, then Complete Solar moves to appeal. Now, of course, they didn't write down that in title at order, but I would say that that was substantially in order. And so therefore it's possible Complete Solar has waived or missed its deadline.
You know that if they tried to bring that up here, we'd send it right back and say, you need a final appealable order, not an open, right? You know that.
Well-
Mr. Billen, just real quick, do you agree with counsel, about the standard review? Do you think this is entirely de novo, or do you have any, disagreement of any of the issues or factors?
Yeah, so I think it's a mixed issue of law and fact. So the arbitration law is law, but what does the clause say? I would say would kind of be a fact issue. And so, I'm not exactly sure the mix of law and fact. But we are entitled to deference on the facts. So prejudice seems probably like a fact issue. And so if the trial court found there was prejudice, that might weigh in favor of us. Substantial invocation is probably more of a law issue, but I think it's mixed. And I'm not sure exactly the mix of law and fact there. But I don't think I agree that it's all law.
And can I throw out one more question to you, about the scope of the claims? Are there any claims that you believe are entirely outside of the scope of the arbitration clause? If we were to find against you on waiver?
So I've done a little bit of research on this in terms of contract claims versus tort claims, and I believe my understanding is that they would kind of all go together, which is also kind of why it's important for us. It would be kind of crazy if us and Complete Solar were compelled to arbitration, but we somehow had to still litigate against Dividend in court, which is why I think Mr. Boatwright's position that dividend doesn't matter is incorrect. And I'd also
But
argue.
Mr. McMillan, isn't that for an arbitrator to decide if we determine that, I mean, we're just here to, as a court, to decide whether the arbitration agreement is valid, whether your claims fall within the scope. But as to fraudulent inducement, for example, in entering the contract for solar panels, I mean, whether that's arbitrable or a court matter anyway, isn't that for the arbitrator to decide if we send this to arbitration?
So I think the applicability of the arbitration clause on this interlocutory appeal is for the court to decide. As far as the other issues, I believe they probably would be for the arbitrator to decide. If I lost the argument, it was moved to arbitration. But there's kind of a, they're a little bit mixed and muddied, and I guess I'm not completely sure how to answer that.
Is Mr. Fu arguing that he was fraudulently induced into signing the arbitration clause? Or is your argument that he was fraudulently induced into signing the contract for solar panels in general?
So that is one of our minor arguments, that we were fraudulently induced. So, generally we're relying on Perry Holmes and the substantial invocation. The initial, we argue, of course, that there was fraud everywhere, but I guess what I would say for the fraudulent inducement would be perhaps the first arbitration clause was valid, but then when they sort of have us, under the ropes, right? They have us sort of relying on them, and then they get us to sign the contract modification in December. That's when you could argue that they're fraudulently inducing us to kind of keep us going after they've already defaulted on their contract, would be what I would argue in the alternative.
Thank you.
Thank you,
And
Congress.
Mr. Boatwright reserved 5 minutes for.
Thank you, Madam Chief Justice. Um, I, I would like to begin by discussing the substantial invocation. Um, I'm not aware of any case law that he cited in his brief or in the argument today that would support the idea that just responding to one piece of discovery would constitute substantial invocation of the judicial process. Instead, as we cited previously in our trial court briefing, the Texas Supreme Court has specifically held that a party's litigation conduct aimed at defending itself and minimizing its litigation expenses rather than taking advantage of the judicial forum does not amount to substantial invocation of the judicial process. That's GT Leach Builders versus Sapphire from the Texas Supreme Court in 2015. There is no, I am not aware of any legal authority, and he cites none, for the idea that just responding to one request for production substantially invokes the judicial process. I think that Perry Holmes supports the proposition that we did not substantially invoke the judicial process. We did absolutely nothing like the movement for compelling arbitration in that case. I'd like to quickly follow up with pointing out that he argued in his brief that Perry Holmes has been overturned by the U.S. Supreme Court, which I find difficult to believe. He says that Perry Holmes, he cites it as his main case, but he says it's been overturned. I don't think the U.S. Supreme Court overturned Perry Holmes. I think the court expressly said that it was not applying on state law, and that it was not, and that it was deciding the case on the basis of a judicially created prejudice requirement that applied only to arbitration in the U.S. Circuit Courts. In contrast, Perry Holmes was about a prejudice requirement that arose in estoppel and applied to contracts generally and was not specific to arbitration. I think Morgan did not apply to state law, and even if it did, Perry Holmes is fine. But just besides that, yes, ma'am.
Sorry, in regard to how we are to view the weight of the Morgan case, because it's decided in 2022, Perry Holmes is earlier. And one of the things that I gained from reading the Morgan case is just this US Supreme Court's trying to clear up the notion that had accumulated over the years, believing that the Federal Arbitration Act had included some favoritism, that we were supposed to favor arbitration. And if anything, Morgan just clears it up and says that there's no need to foster arbitration. It's just contractual as any other contract. And do you agree with that reading of Morgan, or does Perry Holmes, is it consistent with that interpretation of at least the FAA itself, because that's where the US Supreme Court would be the authority on that act?
Your Honor, I don't think that the U.S. Supreme Court's analysis depended on any kind of policy evaluation of whether to favor arbitration or not. I think it relied entirely on the idea that this was an judicially created arbitration-specific prejudice requirement that had no that had no support in the text of the FAA itself. And I think that Perry Holmes would survive under that analysis with flying colors, because the Perry Holmes court said in absolutely no uncertain terms that its prejudice requirement, the prejudice requirement under Texas law, is rooted in general contract principles, is not rooted in anything other than estoppel principles and in general contract law under Texas. It's a stark contrast with the situation in Morgan, and of course, I would caution the court about finding that that Perry Holmes has been overturned. I think that is the binding precedent in this court, that we're all obligated to follow it, unless the Texas Supreme Court changes its mind. In the few seconds I have left, if I may, I'd like to just remind the court that Mr. Fu brought this on himself entirely.
I'm sorry to interrupt, but
Yes, Your Honor.
can you speak to Complete Solar's, to any issues that were financially about going to mediation or arbitration? Was that an issue? Was that a factor?
If I remember correctly, Mr. Fu sued, and then they discussed mediation, and Mr. Fu, and if I'm wrong about this, I will correct myself. I promise. My recollection is that Mr. Fu insisted on our paying for mediation, which was not a condition imposed by the parties' contract. It's our position that if Mr. Fu wants to enforce the mediation requirement as a condition precedent, he should not have breached the mediation requirement by filing suit instead of seeking mediation in the first place. Regardless, I think that that's a question for the arbitrators to decide. In closing, I'll just point out that again, what Mr. Fu claims is prejudice, the amount of money that he spent on his lawyers, that is entirely a consequence of his decision to pursue litigation in violation of the contract that he signed and initialed. Thank you very much for your time today.
Thank you both.
Thank you.